Great. So let me get started then. And thank you again, Masako, for the invitation and for this opportunity to give really a quick overview to on the in the UAI Act. And so my plan is to speak around 30 minutes, more or less, and then I understand we will dig into some questions. Uh, the I Act is an extremely complex piece of legislation. So today you will get, I would say, just the very basics. So some of the fundamental coordinates of the EUAI Act. Uh, Keep in mind that the I Act is around 144 pages in the official journal, which is actually also written very small print. So it's really, really complex. But I hope that by going through not many slides, so today I have 5 or 6 slides, I can really give you an appetizer of of some of the basic concepts for you to kind of then maybe do some further analysis and understanding of the Act by yourself. So first of all, let me move the slide. Okay, the risk-based approach is the fundamental idea of the AI Act, at least in its initial formulation. Let me say that the AI Act, so for those of you who are maybe less familiar with the EU, in the EU, there are three major institutions that are involved in policymaking. There is the European Commission, which is the executive, it's like a government. The European Commission is the institution where I used to work. And the European Commission is responsible for making a proposal. So my job when I was in the European Commission was exactly to write the first draft of the AI Act. So without a proposal by the European Commission, there is no possibility that there is a law in the EU. But the Commission, therefore, has this responsibility of making a proposal, but doesn't have the possibility to decide. So essentially, the Commission makes the preparatory work. We went into some of those reflections last time when we spoke 2 days ago around the background of the AI Act. So there has been a lot of work before actually formally presenting a proposal. But once the proposal is presented, it goes to the European Parliament and to the Council. The European Parliament represents the people, it's directly elected by people across Europe, and the Council represents the member states. So why I'm saying this? So I'm saying this because the European Parliament and the Council receive the first draft of the law by the Commission, and they then make the final decision. They have to agree on the final text. So as you can imagine, they represent very different interests. So parliamentary assemblies do not necessarily have the same composition of the government, and they have to agree on the final text. So this is why there is sometimes quite meaningful differences between the Commission proposal and the final legal text, which is the resolutions made by other institutions. Now, the Commission remains very relevant in the process because my job after issuing the proposal was to accompany the proposal with the other two institutions. So we had meetings, we were providing advice, but ultimately the decision-making power does not rest any longer in the European Commission. It rests on these other two institutions. So what I will present to you today is the final, of course, legal text, which is now being adopted. And so therefore, this text has seen some changes, some modification from the initial draft of the European Commission to the final text. Now, the risk-based approach is therefore the fundamental idea of the AI Act. And the idea to regulate not the technology as such, but to regulate the use of the technology on the basis of certain use cases. And when we say risk-based approach, we mean to say that the initial idea was to say we establish the rules, so the regulation should be linked to the risk that the use of the technology creates. So we don't want to regulate uniformly, but we want to regulate the use of technology depending on the type of risk that it creates. So that's the fundamental idea. And what we did was identifying 4 risk levels. Of course, this is somewhat an arbitrary decision. It could have been 5, it could have been 6, it could have been 2. But the point is that we have tried to link the risk levels to certain type of rules, and also to identify the type of rules that would fit well in the context of the EU legal order. So one of the fundamental principles to take into account when governments think about AI regulation is the fact that AI regulation should not be seen in isolation. Regulating AI means regulating a specific family of algorithms or technology. But those technologies are, whether directly or indirectly, already subject to other rules. Whether this is about consumer protection, whether it's about data protection, whether it's about discrimination law, or rules around products. So the complexity of AI regulation is finding that balance between what is actually needed to prevent or mitigate certain risks specific to that kind of technology, while at the same time leveraging the existence of other legal frameworks that are always there in any legal order. So of course, legal order are not always the same, they're different, but there are already other rules. So the effort that we're trying to do is also to create a number of rules, depending on the risk, that also are compatible with rules that already exist. I call this sometimes an exercise of legal engineering, because you really have to take a lot of pieces together and put them in a way that they are overall functioning. Because the final result ultimately is that the legal system works. So going back to our risk-based approach, we identified therefore 3 levels of risk that are subject to compulsory rules. The first level of risk is for applications that may lead to risks that are not acceptable. In these cases, the regulatory response, so what the AI Act says, is establishing certain provisions. In some cases, we have provisions with exceptions, and we'll discuss. The second layer is applications that create a risk considered high. In that case, the AI Act foresees that those applications that are classified as high risk are subject to a number of requirements, so-called AI requirements, for instance, around the data sets, around transparency, around documentation, around robustness. These are generally quite universally agreed requirements, and they are subject also to an ex-ante conformity assessment, a sort of a type certification. Ex-ante means that the system is verified before being placed on the market. So there is a check before the system is sold, essentially. The third category of risk is for systems that may lead to sort of, let's call it, deception or confusion. For instance, we want to make sure that we are aware that we are interacting with a chatbot, so that we know we're interacting with a machine and not with a human. So this type of risks are handled in the AI Act with simple transparency obligation. So essentially, there is generally an obligation to inform. Generally, I would say. And finally, all other applications of AI that do not fall under these first 3 categories they are not subject to compulsory rules in the AI Act. So the AI Act does not foresee compulsory obligations. We'll go through now relatively quickly into
Pwede
each
ako po
layer
para
of risk. When it comes to prohibited AI, so you see on the left hand, these are the use cases that are proposed by the Commission. Persons or systems that exploit vulnerability of persons and result in a harm. Initially, the Commission had foreseen only physical or psychological harm. Now, the final legal text expands to also harm that is not physical or psychological, for instance, also economic. So it had expanded the scope of the provision. The third use cases was about social scoring. So situations where there are systems that essentially rate persons based on their social trustworthiness, social behavior. So these are not the systems that specifically, for instance, credit scoring. They look at specific credit worthiness, which are used, but are more about you as a citizen. Are you a good person or a bad person? The fourth use case was about the real-time remote biometric identification for law enforcement purposes in public accessible spaces. An example of this use case would be facial recognition tools that may be used by the police in a public accessible space, so for instance in a public square, to identify criminals. This use case is subject to a prohibition, but with exceptions. An important element of this use case is the real-time element. So the prohibition would apply not to the use of the system, for instance, on video footage that already exists, but only on the use of the system in real time, so that there is a possibility to identify persons walking on the street, for instance, um, as the persons are there. So it's really the real time element that is important here. The use cases that you see on the right hand side were added by the co-legislators. So we have a doubling, twice the number of prohibitions. The first one is a prohibition for biometric categorization, which infers or categorizes persons based on certain characteristics, like the one mentioned there in the slide, for instance, race, political opinions, trade unions membership, and so on. The fifth use case is around individualized criminal risk assessment when they are fully automated. The next use case is around emotion recognition, so prohibition for systems that identify the emotions of persons in two environments, in the workplace and education, except for medical or safety reasons. And the last use case that was added was about the untargeted scraping of facial images from either the internet or CCTV cameras to build or expand databases. Mostly this use case is linked to the case of Clearview AI, which you may have heard in the United States. Now, moving down the pyramid from prohibited AI to high-risk AI. There are two ways in which systems are classified as high risk. The first one is when the system is a safety component of a product that is already regulated in the EU. In the EU, there is a lot of rules, many regulations around products. For instance, medical devices, toys, machineries, radio equipment. So there are many physical products that are being digitized, meaning so there are some components of the products that are relying on software. The AI Act says that when some of these digital components of more traditional products are AI, And the component plays a safety function, meaning if the component doesn't work properly, there may be harm to persons, then the AI system is high risk. So there is a link between the riskiness of the product and the riskiness of the AI that is a component. So on the one hand, as I mentioned, the AI must be a safety component. And then the second condition is that the product is subject to a third-party certification, third-party conformity assessment according to the sectoral legislation. So medical devices, for instance. We're going to have a software that is a medical device, and that software is subject to a third-party certification. In that case, if the software has an AI, the AI is high risk. There are second categories of high risk AI systems, and these are the systems that fall under certain areas. You see on the screen 8 areas, like, for instance, critical infrastructure, education, employment, law enforcement. The Annex 3 of the AI Act lists all these areas, and under each areas lists certain use cases. You remember we mentioned before the risk-based and use-based approach. So it's important to recall that not all AI systems in law enforcement or education or employment are high risk, but only those systems that are specifically listed. This is an important distinction because sometimes there is an impression that all AI used in a certain sector is high risk, whereas in reality, only certain AI in that sector are high risk because they are more prone to creating certain type of risks. The third category of risk, as I mentioned, is when systems do not pose an acceptable risk or a risk that is high, but it's a risk that is primarily linked to the transparency. Now, I have to say up front that in reality also there are industry risk categories. After the negotiation of the AI Act. So initially, when the Commission put forward the proposal, the distinction between the risk levels, from my perspective, was more strict, was clearer. During the negotiations, there has been some overlaps between those risk levels. For instance, now, if we think about this third category of risk, the systems that are subject to transparency obligations. As you can see here in the slide, the second bullet is about emotion recognition or biometric categorization systems. Those systems in the initial Commission proposal were only subject to transparency obligations. They were not prohibited. They were not high risk. Now, in the final version of the legal text, we have, in some cases, as we have seen before, biometric categorization systems and emotion recognition systems are prohibited. And they're also always high risk. And they're always also subject to transparency obligations. So this is the main example, these two types of systems, where they can fall in different categories, or the different categories can overlap. I also mentioned before the case of, for instance, the chatbot, when we are having a system that interacts within a human. And it's not obvious from the circumstances whether, from a point of view of the human, whether the interaction happens with a machine or with a human. So we thought it's important, in order to preserve human dignity, that humans are aware that their interactions happens with a machine and not with a human. So, but they must be informed. The third category of use case in this risk classification are the deep fakes. So deep fakes is synthetic material, as you may know, that has been created with AI, in particular audio, video, and sound. And we had foreseen already in the commission proposal that a person who uses a generative AI to create a fake video or audio or image has to declare that that content is being created by AI, unless there are some exceptions to preserve freedom of expression. The other two use cases that you see on the screen were added during the negotiations. In particular, looking at the last one, the fifth use case, the Parliament and the Council added an obligation for the user of a generative AI system to also label text. So initially, we only focused on labeling audio, video, and image. But the co-legislators decided to also establish an obligation to label text. So if I use generative AI, let's say ChatGPT, to draft a text, and the goal, the purpose is to inform on matter of public interest, then I need to disclose that I used generative AI, unless there are some editorial responsibility, for instance, in the context of newspapers. The fourth use case, it's actually also quite a new addition, and not probably this is going to be a relatively complex also obligation to fulfill. And this means that the providers of generative AI systems have to develop technical solutions to ensure that any content generated by those systems, whether audio, image, video, or text, can be identified and detected through machine, so in a machine readable format, that has been artificially generated. So we know that there are some solutions that are coming on the market, but those solutions are not always functioning very well. So here the legislator imposed an obligation to always allow great solutions, technical solutions for identifying through machine forms whether a certain content has been generated by an AI. So the last slide that I want to show to you is on general purpose AI models. What we have seen so far were rules applicable to AI systems. So the AI Act was born with the focus on AI applications and applications. That's the term of AI system, means a functioning system. Depending on its use, is subject to different rules. This approach has been somewhat altered during the negotiations following the launch on the market of ChatGPT, which has generated a lot of attention by the policymakers, by shifting some of the regulations or certain rules of the AI Act from the system level to the model level. The concept of general purpose AI is essentially another term for foundation model. You may be aware about the foundation model as these large models that have been around now for a couple of years and that are powering some of the chatbots that we've seen, like the model behind ChatGPT, like GPT 3.5 or GPT-4. Those models are typically trained on large amount of data, they require a lot of compute, and those models are capable of engaging in different tasks. So during the negotiations, the co-legislator added a new chapter to the AI Act, focusing on the model, on this specific technology which is the foundation models. And the rules that they have identified have two tiers. There are certain basic rules, let's put it that way, that apply to all foundation models. So all foundation models must be subject to technical documentation that has to include information around the consumption of energy and the computational resources used for training. There has also be an obligation to provide information downstream, meaning to the developers that want to integrate the model into their own application. And finally, there is an obligation to comply with certain copyright rules, notably to create a policy to show how the provider of the model complies with copyright, and they have to publish a detailed summary of content used for training. And these rules, as this I just mentioned, apply to all foundation models. There are then additional rules that apply on top of those I just discussed when the general purpose AI model qualifies as a model with systemic risks. Those additional rules relate to making an assessment and mitigation of the risks, have a system for reporting incidents, and complying with additional cybersecurity measures. The main question, of course, that the legislators had to solve was how can we distinguish when a general purpose model is a model with systemic risk. So, of course, if you create different rules, you have to create different a threshold for when the rules apply. And this was one of the probably most complex exercises. And at the time, the co-legislator decided to rely on two approaches. The first approach is to rely on the compute thresholds. So if a model has been trained with at least in 10 to 25 flops, the floating operation points. So it's a metric of the compute, the chips used for the training. Then the model is considered a model with systemic risk. Now, recently, with the as you have heard, the launch of DeepSeek, that has been a model that has been trained with equal performance to the latest model, for instance, of OpenAI, but trained with much less compute. This parameter is already somewhat threatened because the idea was the bigger the model, the bigger the amount of compute used, the more dangerous the model is. And now we are having the demonstration that you can have models that are highly performing, but do not use as much compute. So that's been one challenge of applying this metric. The other methodology to identify when a model has systemic risk is a designation by the AI office. The AI office is the European Commission. And so the European Commission has the possibility to identify when a certain model placed on the market on the number of certain criteria that are indicated in the AI Act is a model with systemic risk and therefore subject to the additional rules. So roughly speaking, this is, the rules are, it's a whole chapter in the AI Act, so it's quite extensive. But roughly, these are the key points. These rules apply also to open source models. For instance, DeepSeek is an open source model. In principle, it could be subject to these rules as well. I think I'm 2 minutes out of my time, so I'll stop it here and I take just a second break to get some water, and I'll and then be happy to answer questions.
So thank you very much, Mr. Mazzini. It was very comprehensive, and I was really interested in about the risks that are unacceptable. So when it comes to the emotion analysis system that is banned in schools and workplaces, but in Japan already in several schools, they already have the system where they have wristbands to observe the physical status of the students to see how much they are focusing on the classes. And also, we even in the businesses, they have devices to observe the levels of their employees, their emotional status, and see how they are communicating to measure the happiness level of the employees. So that kind of things is something that is taking place here, but I understand that in Europe that is not allowed. And so have you had any such kind of discussions in Europe, and have they been done in Europe? And also, were there any opposition from the businesses and educational institutions who would like to make use of these kinds of devices? So, were there any opposition from the businesses or from the schools in Europe?
So I'm not aware of these applications being used in Europe. To be frank, like the one you mentioned, like the monitoring of the polls of students. And to be frank, the reason why applications will not be discussed in Europe is not really the AI Act, but the General Data Protection Regulation. So, as you know, in Europe, we have extensive data protection legislation. And so, data protection legislation, among others, already regulates. So, first of all, it's about the way and the conditions under which personal data can be collected. This can be any personal data, including also data related to health. For instance, the polls is a health data. So the GDPR already provides a comprehensive companies, public administration can collect and process personal data. This regulation already regulates biometric categorization, already regulates profiling. Um, and therefore, the AI Act, what happened was that the AI Act de facto creates an amendment of GDPR by making the processing of personal data by an AI more restrictive. This has not been part of a wide debate because this has been added in the course of the negotiations. As I mentioned before, the Commission did not foresee any special rules for emotion recognition or for biometric categorization for one simple reason, and that's because those practices are already regulated in GDPR. GDPR already says when, for instance, what are the legal basis under which my personal data regarding health, for instance, can be collected and for what purpose. So in our initial thinking about the AI Act, we thought that that matter is already comprehensively regulated by GDPR. So we did not think that it was necessary to add additional rules in the AI Act. But this is what ultimately was decided. I personally don't think it was necessarily a good idea because a prohibition is extensive and a prohibition may have sometimes unintended impacts, but we will see what whether this was a good or a bad choice.
Thank you very much. For unacceptable risks, facial recognition data collected from the internet, use it as a database is also prohibited. So You talked about it being something like Clearview AI, and I believe this is regulated according to the current regulation, right? So with AI Act, depending on the purpose, so my understanding that will be prohibited regardless of the purpose.
Yes, that is correct. The Act foresees this prohibition for the fact of collecting the data, regardless of it says for the purpose of building a database. But indeed, there is also, first of all, there is a question that, of course, if it's about personal data, that is already subject to GDPR. So my data that is being scraped on internet, if I'm a European citizen, my data is subject to GDPR. So it cannot be scraped indiscriminately, regardless of the AI Act. And second, there is a second question about if I scrape the data without AI, then there is no prohibition because the AI Act only applies to AI systems. So it applies to AI system that collect data. So this prohibition, in fact, is, from my perspective, more of an emotional reaction to the Clearview use case, creating a sort of a ban on scraping images. But in reality, the added value of this prohibition is a bit unclear. Because in the EU, at least, we already have data protection legislation. And so that is already putting conditions for the use of personal data that may be available on the internet.
Understood. But for example, in things like SNS, if you get an consensus from the user that the personal information will be collected, you cannot build a database utilizing the data available on the internet, even there is a consensus from the user.
Exactly. So this goes beyond data protection. So even if I give consent, in principle, this prohibition would prevent that from doing that.
So understood. Smart goggles or smart glasses, which is getting a lot of attention. Use smart goggles, take photographs of the people on the streets, and identify that person using the system will also be prohibited. Is that correct?
I think that use case may not be prohibited because, let's say, here is about building a database. Unless, if I use smart glasses occasionally, I'm not trying to build the database for me. So the focus is building on the database. But certainly the use of smart glasses in the EU will be subject to the GDPR. So in a way, if I process personal data of persons with smart glasses, there may be some questions that could emerge from the GDPR point of view, but I would not say that the AI Act would prohibit that.
Understood. Thank you very much for the explanation. And now, for prohibited AI, for the real-time remote biometric identification system to be used for law enforcement purposes in public places. Basically, it is prohibited, but there are some exceptions. For example, if it's a victim of abduction or to search for missing persons, or if there is a threat to people's lives. I'm sure that I understand there are some exceptions. How do you expect this to be enforced? For example, if it's a search of a missing person, there are cameras on the streets and they are not turned on, but when there is an incident, the camera can be turned on and the data could be, and system can be used for real-time purposes. But in the exceptions, there is an exception related to the prevention of terrorism. For that, maybe real time is necessary. I was wondering how this would be enforced and operated.
Yes. The idea of that prohibition is exactly to prevent the undiscriminate use of the real-time identification of persons, but allowing that to happen when certain conditions are met. And these are the conditions you met. So let's say there is an indication that a person is missing and may be present in certain areas rather than others, and therefore the police could activate the feature of the AI to essentially scan real time all persons passing through a certain public square and matching it potentially with the person that is being targeted. So it's indeed the law foresees the fact that you can trigger, so you can activate this feature on cameras, but you need to have an authorization. So the example of the missing person or the example of a terrorist threat, these are all, certain quite restrictive conditions. There has been a lot of concern around the fact that this technology could be abused. So on top of having these conditions that are in the law for activating the camera, there is also a number of additional requirements that the police must satisfy, such as, for instance, doing a fundamental rights impact assessment, such as, for instance, notifying, so requesting an authorization either to a judge or to an independent administrative authority, notifying the data protection authorities and the market surveillance authorities. They also have to create a report of all the time that the technology is used. So in practice, there has been quite a number of additional elements that has been introduced, which I believe may make the use of the technology quite difficult in practice going forward.
Thank you very much. So now I also want to know about the differences between unacceptable AI and high-risk AI, especially on which side it is, because if it is something that is related to basic human rights, then people have difficulty deciding whether it is unacceptable AI or high-risk AI. So is it only just looking at the level of the risk, whether it's high or not, or are you also comparing this with other elements and then trying to make a decision from a more comprehensive standpoint? For example, about emotional analysis using biometrics. They are banned in schools and workplaces on the one hand, but then you can use it in other circumstances. But for example, in shopping centers or other public areas, I mean, if an emotional analysis is taking place, then that is a violation of human rights. So how did you categorize between high-risk AI and unacceptable AI in this regard?
So that's a good question and quite complex. I'll try to keep it as brief as I can, but it's a complex question because the AI Act was born primarily with the goal to ensure that when certain systems can lead to unintended impacts, primarily around discrimination, for instance, because you may have a remote biometric system that doesn't work well for women, or doesn't work well for children, or doesn't work well for people of color. So there is a risk that the performance of the system may be different. And so there may be a risk of discrimination. So in that case, the IACT, basically by classifying the system as high risk, wants to ensure that people are treated equally. So this is the main, I would say, origin of classifying certain systems as high risk. But initially, we did not want to discuss too much about when it's fair to use the system. So as a product legislation, the IACT intended to prevent certain risks that if the system was not trained properly, certain discrimination effects would happen. But whether it's okay to use, let's say, a remote biometric system all the time, or real time, or ex post, or in a public accessible spaces, or in a private environment, these are questions that are more linked to the use as opposed to the um, the way the system has been developed, the way the system has been created. So the prohibitions are more linked to the use as opposed to the way the system is being developed. Therefore, you may have in that sense an overlap between high risk and prohibition, in the sense that if we take the example of remote biometric identification, the system is classified as high risk. So I want to make sure that if I use the system performs equally for everybody. So that's the goal of classifying the system as high risk. But then, okay, because the system can be used to generate a sense of surveillance in people if it is used everywhere in real time, then there's been some advocates for saying we also need to regulate the use. We need to subject the use to certain additional conditions. And if those conditions are not met, the use is prohibited. So this is an example where you have the same system that is classified as high risk, but it can also be subject to certain prohibitions because of the use, not because of the way it is built. Similar considerations happen for emotion recognition and biometric categorization. But just to finish on this point and not to take too much time, when classifying a system as high risk, we do not consider the benefits. So there is no risk benefits analysis in classifying a system as high risk, because the rationale of classifying a system as high risk was to say if the system can be used in a situation where there can be discrimination, we want to ensure that we reduce or eliminate the risk of discrimination by making sure that the system is built properly, regardless of whether the use of the system may have certain benefits. So that's a bit the rationale. Hope I know this is not enough. This is a complex question, but I hope I've given you some useful elements.
Thank you very much. Yes, that was very, very informative. So the next one, so I think it's true with GDPR as well, but so the high-risk AI uses, so I think it is also important to the human use. But I think in the Wisconsin state case, they use some algorithm in judicial adjudications, and they said that they can take it into consideration, but the final judgment must be done by a human. That is what the court in Wisconsin said. So the involvement of humans is something that many people say to be necessary. But there is also this possibility of the human side making an error. And recently, about the Tesla autonomous driven car in an emergency, stopped the autonomous driving function and handed over the final decision making to the human driver. But that is just seen as a way of giving all the responsibility to the human person and giving up its own functions. So, what kind of thought was going behind this? And so, I would like to hear what your thoughts are about in these kinds of situations.
So when we decided to establish a requirement for human oversight for AI systems, so essentially, let me say first that the whole strategy of the EU on AI is about human-centered. Human-centered means that we want to ensure that AI as a technology is at the service of humans. So it's centered around the human. So the human remains in control. The humans, the technology serves the human and not the opposite. So that's philosophically, I would say, really, the the foundation of the approach. We want to make sure that humans remain at the center. One dimension of this human-centered approach of AI is one important dimension is the human oversight. The human oversight is the legal requirement whereby AI systems need to be developed in such a way so that they can be controlled by humans. That doesn't mean that the way in which the control to be exercised by humans is always the same, depending on regardless of the AI system. As we know, AI systems can be used in many, many different ways. It can be used to assist in decision making. It can be used in controlling, monitoring certain situations. It can be used in controlling certain processes. It can be used in robots or cars or drones. So, as you mentioned, there are many different ways in which AI systems can be used. So, in the AI Act, we established this general requirement for human oversight, but we did not enter into the specifics of what that human oversight can look like. We indicated, for instance, in Article 14, certain examples, but we did not prescribe that, for instance, there should be always a human that can interrupt the cycle of an AI system. Because as you correctly say, there are situations where having a human intervene in a process, for instance, in a case of even more dangerous. Flexibility. So we expect that the details around how human oversight should be exercised will come from the standardization efforts that ideally should provide more specificity to, depending on the type of system, what should human oversight should look like. But the point is that human oversight for all AI systems.
Thank you very much. Now, about high-risk AIs. In the case of high-risk AI, there is a need for CE marking. I understand CE marking will be used for high-risk AI. Already, things like medical devices, machines, and toys. For securing the safety of the products, there are regulations and directives. And this is a kind of certification system for those products that they fulfill certain requirements. In the case of AI systems, unlike toys or medical devices, algorithm could become black box, very difficult to certify, I think. The sellers is going to declare that it's certified, but whether or not that certification is correct, how are you going to judge whether or not what the manufacturer is saying is correct, even if they declare that they are in conformance with the regulations?
I expect that over time we will develop the tools and methodologies to find a common ground on how to verify the claims made by the manufacturer. There is no question that this is an area where more work is needed, and that the certification of AI systems may not be today an area where there is already, let's say, common practice. But the reality is that even if we didn't have an AI Act today in Europe, we would still have, today, we have, for instance, medical devices that have AI. Those medical devices are already certified according to the medical device regulation. So today, we are already witnessing the presence of AI in certain products that are subject to certification. The AI Act has tried to align and to create a common ground for the issues, for the questions that needs to be looked at in the course of the certification. For instance, as I mentioned, the data, the documentation, the transparency. So the goal of the AI Act is to add a layer of checks about the specific components of AI that may lead to safety risks when it comes to certification of products. By doing so, of course, we have pushed the boundary of efforts that certification bodies have to undertake. And I expect that this will take some time to develop indeed the tools, the methodologies to actually assure that a certain product with AI aligns with the requirements. And in that sense, I think the AI Act has set a bar for manufacturers, for authorities to reach. This may take time, but in any case, if we had not done that, we will still have to face the reality that today certain products already have an AI. So I think this is a challenge going forward, but from my perspective, it was an inevitable challenge that we had to confront. And we expect the technical communities to also invest energies and resources in this direction to ensure that whenever we have an AI as a component of a product, that AI is also certified together with the whole product.
Thank you very much. 2 days ago, we heard your lecture, and this question is related to what you mentioned 2 days ago. Mr. Mazzini, you said that you received many claims from different stakeholders. And Mr. Mazzini yourself interviewed many people, and you had dialogue with different stakeholders. That is what you mentioned 2 days ago. And organizations who are likely, who are more capable of collecting information had more power. And the global platformers, for example, that have a lot of funds, could be one of those players who have more power. So that was what I was thinking as I listened to what you mentioned. But ultimately, it was the commission that presented the proposal. And to do that, there's a need to secure the independence of the commission, and you need to have a lot of resources. And that is only when you will be able to provide a proposal, regardless of many claims from different stakeholders. ChatGPT has started explosively at the end of 2022, and OpenAI, Google and CEO and Google CEO met with people in the commissions. I understand that there were a lot of lobbying activities of the top management of the major platformers. How did you respond to them? Were you able? I'm really interested to find out how you were able to push back those platformers and how you communicated with them. I would like to know what kind of team you have. What kind of backgrounds do your team members have? So that is an additional question I wanted to ask you.
Yes, I see you have a lot of interest in these aspects. Important also, as you say, regulators must have an independence compared to the stakeholders that are being regulated. So I think, as I said last time, it is normal that regulators speak to everybody, including, small companies, big companies, everybody, because everyone is impacted by the rules that the regulators issues. So this is part of the game. It's normal that regulators speak to everybody. But as I said last time, regulators must not be captured. Regulators must make their own choices on the basis of the evidence that is being provided. So the best recipe to maintain that independence is competence. So regulators must invest in their own capacity, must invest in their own knowledge, must invest in their own competence. Because if I do not know what I'm doing, people can tell me everything, and I would not have the possibility to verify. So I think this has been my main focus during all the time I worked in the European Commission. I always listened to everybody, but I always listened with the filter in mind. So knowing, of course, that if I speak to a big tech company that has an interest in developing certain products, of course, that company would tell me a story that would be aligned with their own business. It's normal. But it's my responsibility to be able to read in between the lines, to verify whether the information that is given to me is correct. And so really, I personally invested a huge amount of time studying as much as I could. I mean, I've been working on AI policies since 2017. And I've tried to surround myself as much as possible within the limits, of course, of public administration. Sometimes have limited resources, but I've tried to have conversations with people outside the commission, to have people outside, let's say, academic institutions that could provide me advice. So I made the point of really investing in becoming as competent as possible and relying as much as feasible in the support of people and colleagues in the commission that even if they were not working directly with me, because maybe they were belonging to a different department, but they had the competencies to help me understand the claims that companies or stakeholders were offering. So I made a point of working with scientists in the European Commission. The European Commission has a separate department for science. They are researchers. They are typically not involved in policymaking because policymaking is more done by people like me, who has a legal background or economist background. So I really wanted them to be involved. So I brought them in certain conversations because they were giving me an objective view about whether certain claims made by, for instance, tech companies about how algorithm works and about data, I cannot understand them because I don't have the competencies. But by relying on them, I think I could manage to, have a balanced approach. And then again, I mean, I worked very hard. I studied a lot, um, and so within the limits that we had, I made the point of maintaining competence and independence.
Thank you very much. So the legislation team and the scientist team, how many people were they in each team? So when you in the team where Mazzini-san, where you formulated the AI legislation, how many people were in that team?
You will be surprised. So my team was composed of 3 persons. So I conceived the whole AI Act by myself. After years of studying and research, and then the AI Act was written with the support of 2 other persons. Then we had other colleagues that were somewhat involved in the proposal, but also there were the impact assessment, there was the consultation. So there were other administrative actions and steps that had to be made. So my focus was on the legal text. Then other colleagues were doing some of the work that was, if you want, ancillary or accessory to the actual legal text. But my focus was on the thinking and on the structuring and the drafting of the legal text, sometimes receiving input by other colleagues, but the core work of drafting was done by 3 persons. And I also relied on primarily 2 external experts from my own department, part of the commission, still part of the commission, but a different department, that were the scientists. So they were data scientists and machine learning. And those colleagues also had a team, each of them, maybe 3-4 persons each. And so I was relying on these 2 colleagues on the more technical aspects, and on the policy legal aspects. Basically, yes, I was leading a team of other 2 persons.
Well, that was very surprising. Just 3 people. So you had 2 people with legal expertise and one more person with another set of expertise. Wow, that was really amazing.
Yes, then you have to consider that, of course, we were always, as I mentioned before, we were constantly open to discussing with stakeholders. So we received a lot of information from stakeholders, from other colleagues. The process of then crystallizing, so taking that information and transforming that into an actual legal text, that was done by just a few people. Also because it's important to not forget that laws have to be coherent, laws have to be consistent. So if you have too many hands, the risk is that you develop something that is not always coherent. So, and if I may say, this is one of the challenges, in my view, of the final legal text of the AI Act, because the final legal text has seen many more hands on top of the law. And therefore, the clarity of the legal text is impacted because when you have too many people that have the pen, then you lose the coherence of the story. You lose the coherence of the endeavor. So a law is also, if I can say, something that requires, in French we say fil rouge, or so is a red wire. So there must be something that aligns, something. It's almost like a, an exercise of art. You have to be able to create a, a functioning system that is also harmonious. And if you do not take care of that, to have a a common mind or a common approach, but you just add pieces, the risk is you create inconsistencies. So in that sense, I mean, regardless, of course, of where one person stands in the political choices, but the Commission proposal was certainly more coherent than the final legal text.
Thank you very much. So this will be the final question for myself, but I think that President Trump recently is said that AI regulations are outdated, and that in order to win the geopolitical competition over China, AI is an obstacle, is what he seems to be saying. So is there a risk that AI governance will no longer function in the future? So in Europe, you have the GDPR, and you have exercised influence all over the world in terms of data protection. But if the United States is going to a different direction about regulating AI, so that means that EU will be the only region with stringent regulations in AI, whereas the rest of the world is not that stringent. And so if you look outside of the EU, what kind of a risk will humanity have in terms of AI regulation not working well outside of the EU? So with that, when you look at the global situation, what are your thoughts about this going forward?
Yes, I think that the EU has invested a lot in the Brussels, as you correctly mentioned. So whether it was about privacy or indeed AI, so the idea to shape outcomes also beyond the EU jurisdiction based on certain values, and therefore promoting some degree of alignment in other countries to the EU approach. And there are maybe good reasons for doing that. The Brussels effect is a concept that is widely also. There are elements supporting it, but it is also true that it hinges upon two elements. So on the one hand, there is the element of the companies that basically say, I want to have one set of rules. I prefer to have one set of rules because I want to do business everywhere. And I prefer to create the procedures and the processes in my company to align with the EU everywhere. So in a way, you may have an extension of the rules of the EU outside the EU, because the companies say, I will align. Even if, let's say, in Japan, I don't have an AI Act, but because I want to sell the same AI system in Europe and in Japan, I'm going to apply EU rules. So this is one possibility for which of EU rules outside the EU. The other mechanism is linked to a political decision in other countries. So you may have indeed countries that say, okay, regardless of what my companies are doing, as a factual decision, as a business decision, I want my legal system to align with the EU. This could be the US, this could be Japan, everywhere. So countries have their own jurisdiction about the rules in their own jurisdiction. And they may want to decide for political reasons or economic reasons to align. Clearly now, as you mentioned, I think the US administration does not seem to have a similar approach when it comes to AI compared to the EU. I do not know. I mean, you mentioned yourself, I think, last time that in Japan also it does not seem like Japan is aligning with the AI Act. So certainly the fact that the US administration may want to push back on certain type of rules could undermine a bit this potential extension of the EU rules by way of political decisions. Whether that is, bad for the world or bad for, AI governance, I don't know. It is difficult to say. I believe it is important to have a dialogue. So regardless of the choices that each jurisdiction does in their own boundaries, I think this is the way our legal systems operate. We have jurisdictional boundaries. It is important to have a dialogue and to try to find as much as possible a common ground. That, in my view, is the best way to create an alignment, to have a dialogue. And for that, you may want to promote internal legislation or not, but it's important to maintain an ongoing dialogue. So hopefully that gives you some indication about. But it's difficult to predict the future. But I'm always hopeful that dialogue is the best approach.
Thank you very much. So that was all the questions I had. But I would like to ask the audience if they have any questions. So instead of me asking the questions all the time, I would like to ask the audience if anybody has any questions. We still have some more time. Any questions from the audience, please? Yes, I see a hand. Professor Mori, please. Thank you very much. Mr. Mazzini, thank you very much. It was a great, thank you very much for great inputs. It was a great learning experience for me. So I have a question for you. 2 days ago, Ms. Wakui mentioned something. It is related to that. In Japan, it would be difficult to come up with something like AI Act in Japan. So my question is, why is it possible that EU was able to come up with a AI Act? Let me explain the reason why we are not able to do that in Japan. Because in Japan, it would be very difficult to apply such a restrictive law on a new technology. There will be a lot of oppositions from the industries, and the ruling parties, parliamentarians, would oppose to the legislation, because they are being supported by big companies. So why does that not happen in EU? So I imagine that I have some scenarios that I imagined. Scenario A is that industries do not like to have a very restrictive legislation, but if you oppose to it, you will be criticized by the public, which may cause damages to the reputation of the company. So they would not oppose to the legislation. They would rather have a dialogue with the legislative team, and if they they would not force their requests. And the scenario B is that industries do not have stringent laws, so they would go to the politicians they have good relationship with and say that you shouldn't be coming up with a legislation. But the politician would say that if we accept your request, I will my reputation will be at risk. That is probably what the politician would say. Maybe it's either of the scenarios. So my question is, why is it that it was possible for EU to come up with the AI Act? And that could be useful for our future uh, legislation activities.
Thank you for the question, and thank you also for the explanation about the situation in Japan. I'd certainly be happy more about what are the complexities and um, the dynamics that are happening in your country to as you discuss and reflect about the importance of AI governance and AI legislation. What I can say from the perspective of the EU and having lived this in the first person, I have never felt that the EU would not be in the position to have AI legislation. Quite the contrary. I've always had the feeling that both from the perspective of the administration, and the commission is a political entity, so we have political leadership because the press politicians that are appointed by the member state, but the administration is a quite powerful structure and machinery. So it hardly happens that the commission proposes legislation that is not adopted. So generally, all the legislation that the commission puts forward are adopted. But as I said before, it's not so. The commission is a very powerful entity in proposing legislation, and that is primarily, let's say, um, moved by that is permanent. But even beyond the commission, when you go to the member states and the parliament, you hardly see strong opposition. So I feel that the situation is very different than, for instance, the US, where you typically have a Congress that cannot legislate. So the members of parliament are very reluctant to take action. This is not the case. Also, a strong sense of civil society that often advocates for the opposite. So the positions by industry are certainly, as you know, I know Mrs. Valkai was very interested in this, and I think she's right. Uh, I think the position of industry is very present, but it's also very present the position of civil society, human rights organizations, consumer organizations. They also make their voice heard. So this creates a situation where, as you maybe pointed out, there is an issue about not wanting to be seen as fully captured by economic interest. That politicians generally tend to be open to have legislation. Maybe it's a matter of trying to fine tune to find a balance. Uh, but I've never seen a situation where I've never felt in a situation where, oh, the AI Act will collapse because of economic interest. Um, I would say probably quite the opposite. Uh, the AI Act was adopted also very fast, and in particular, including adding a complete new chapter on general purpose AI models, even without a proper assessment of the consequences of that step. So for me, it was actually even too fast because the issue is so complex that requires some thoughtful approach. I'm not saying that then the solution should be okay, we don't regulate because we just follow interest by the industry. But it's important to have a thoughtful approach when you regulate something that is so groundbreaking as AI, that is a technology that has opportunities and risk. So my argument is we need to have evidence-based policymaking, whether the evidence comes from industry or civil society or consumer organizations. We need to listen to everybody, but we must base ourselves on evidence. That should be the benchmark on the basis of which we should move forward with legislation or not.
Thank you very much. Civil society, consumer advocates, their power is very weak. This goes the same for a political power as well, but they don't have the power to convey their messages. I think that is a major difference between EU and Japan. I think that is the area we need to improve. However, that's going to be difficult. But I was able to understand the decisive difference between EU and Japan. Thank you very much. Thank you very much.